Welcome back to the channel and thank you for watching, and please do feel free to smash that like button at any point you find this video useful, and hit the subscribe button and I'll be truly grateful. So in this video I'm talking about the definitive way of challenging a parking ticket, or any other kind of ticket for that matter, and some of it will be specifically referenced to the United Kingdom, but these are general tips and guidelines that us as lawyers will use throughout the world. So I am a practicing barrister in the United Kingdom and I help you to understand law. So first of all, it's really important to know whether it is an official parking fine or any other kind of official fine, or whether it's a private ticket, because there's a big distinction between the two. Private ones in the United Kingdom are known as a parking charge notice, the charge being an administrative charge that they are charging you for breaching the terms and conditions of parking, and I trust that there'll be similar variations in other jurisdictions. However, a penalty charge notice, as it's known in the UK, is a fine because it is a penalty. The distinction has been argued robustly all the way to the Supreme Court in the United Kingdom in 2015 in Beavis against Parking I, because he argued that it was a penalty and that the private company did not have the authority to issue him with a penalty. The Supreme Court ultimately decided that it was just a fair administrative charge for dealing with the fact that he was in breach of contract. So whilst the UK Supreme Court decision is not directly binding on other jurisdictions, you can bet that other jurisdictions will find that persuasive. For example, Supreme Courts in the US or Australia, or anywhere else for that matter, are persuasive on UK courts, whilst they might not be directly binding. This is particularly relevant where there are issues of law and the rule of law is challenged in how it's to be applied in any given case. So with all that said, knowing which one it is the most important, because there'll be certain timeframes and restrictions applying to each one. For example, in the UK, a penalty, which is the fine version, you have 28 days within which to challenge this. Although if you do an informal challenge within 14 days, which is the period in which it is halved, your informal challenge might be accepted, and then even if that fails, you might still only have to pay half of it. One thing to note, and this is probably relevant for most jurisdictions, is don't pay the fine if you are planning to appeal, as in a formal appeal and challenge to the ticket. If you pay it, this can very often in most jurisdictions be seen as an admission that you are liable for the fee that has been charged and penalty charge that's been issued to you, and so generally speaking you should not pay it if you plan to appeal it. But that comes with a warning that you really should have a very good reason for appealing it. Saying that it's not fair is generally not a good enough excuse. There normally has to be a very good reason. A good reason might be, and again this is fairly international, if the lines on the floor were not clear, partially obstructed, covered in leaves, covered in snow, or just some other thing obscuring them so that you can't see what those lines show. Similarly, if the sign that tells you what the restrictions are on that particular road, on that particular day and time, if that is, for example, turned around and you can't see it, or it's too far away, the writing is too small, again it's been faded, covered up, blocked by trees, covered with snow, any of these kind of things, if you can't see that sign from where you are, this might be a very good reason to challenge the ticket. Some more rather obscure reasons might be that the lines on the floor are not actually in force at that time. There was a very interesting situation back in February this year in the UK where a local authority had just forgotten to reapply for these lines to be in force, meaning every ticket that they'd issued for people contravening these lines was null and void, and they had to refund hundreds of thousands of pounds worth of fines they'd issued because these lines were simply not in force, because they hadn't been reapplied. Again, this is possibly the case in many other jurisdictions. No doubt they will have to have authorization for these lines to be in force and to be able to fine you. So it's always worth checking whether or not these lines have been enforced. That is what we as lawyers would do if you come to us trying to challenge one of these tickets. Another reason might be that you didn't own the vehicle and you were not responsible for the vehicle at that time in question. Clearly, if you didn't own the vehicle, you weren't responsible for the vehicle, and especially if you weren't driving the vehicle, then it's someone else that's contravened those rules and it should be them that receives the fine. Whilst any authority, whether in the UK or elsewhere, they are going to write to the person to whom that vehicle is registered. and they are going to either just levy the fine against you unless you can prove otherwise, or ask you to notify who the driver was or who the keeper was at that time, who should be responsible for that ticket. Again, as I say, if that wasn't you, that could be a very robust challenge that you should not be liable for this fine. As to the private versions, the private parking charge notices, again, this will apply most likely whether it's in the UK or elsewhere. These are going to be a private invoice and they are not going to be a fine as such, because only an authority has the power to fine you. In this case, certainly from the UK perspective, or England and Wales, which is where I practice, they can only do anything about the money that they say you owe them by taking you to court. They cannot just turn up and take your vehicle because they say you owe money. They cannot, let's say, get an attachment to your earnings and take the money directly from your employer before it comes to you without going to court first. They certainly can't just turn up and take goods away because they don't have the authority to do that. They need an order from the court to be able to enforce that money that they say you owe. And they can only do that once they've been to court, and then you get the opportunity to make your representations, just as you would do if you were challenging a fine within the specific time limit. You can go to court and defend it on all the same reasons that I've just said. Maybe it wasn't your vehicle, maybe you weren't liable, maybe the signs were obscure, maybe there were no signs at all, maybe the lines were broken, maybe there weren't any lines at all. Maybe the ticket issued was just plain wrong and you absolutely disagree with it, and you can point out that specific portion of road did not have those rules that you could have contravened. Therefore, if you didn't contravene those rules, you can't be fined and you can't have a parking charge notice for it. But the most important thing of all, as a lawyer, I would advise you, whatever jurisdiction you are in, is to take as much evidence as you possibly can. Most of us have these things around and we can take these with us and take contemporaneous evidence by way of photographs, because the Meta and the EXIF data on this phone is going to take the photograph location, if you've got locations turned on, the date, the time, everything about that specific location. It is one of the most persuasive contemporaneous pieces of evidence you have. For example, if you are at a specific location and you aren't sure and you take photographs of the signs as they were at that time, and then later it's perhaps changed. I have known this on at least one occasion. The sign has changed in the interim, and so a fine was issued even though it wasn't valid at the time this person was there. But moreover, and even if you're going back to the scene of the crime in the first place to gather some evidence because you want to challenge this, the evidence is key. As much evidence as you possibly can, with as much detail in the written representations as you possibly can, is going to help you challenge one of these fines. Or in the case of the private versions, which are technically an invoice, going to help you when you go to court to make your representations. Simply saying that you don't believe that it's accurate may have some sway with a judge, but it's not likely to have nearly as much sway as you having photographs to show that maybe the sign was too far away to see, the writing was too small, the lines were obscured, so on and so forth. The more evidence you have, the more likely it is that any judge is going to side with you and say, well, on the balance of probabilities, which is what civil cases are decided on, the judge might then say, well, on that balance, you are probably right if you've got evidence to show that this wasn't fair. So the main takeaway point from this, if you haven't gathered already, is gather the evidence, because cases are won and lost on the amount and the quality of the evidence. So this actually applies to any case you are in whatsoever, whether it's a fine that you're challenging or a private dispute with another company or another person. It's all down to the evidence. For example, if you have an injury and you want to blame someone else for negligence for not keeping the place safe, then you ideally should take photographs of the scene, the day of, the day after, the subsequent weeks to show that there's a pattern of negligence, and photographs of the injury showing how long that injury took to heal. If you want to say the injury took 5 weeks to heal, but you only have one photograph on the day of, then you don't really have anything other than your word and any doctors that you've seen to say that this took that long to heal. However, if you have medical records and certainly photographs weeks after the event to show that this is how long it took. Again, the photographs are going to have date stamps on there. Yes, on the one hand, they could be manipulated, but on the balance of probabilities, it's not really likely that you're going to do that, and a judge in a court of law is not going to assume that you've changed the dates on these things. So again, on the balance of probabilities, these photographs are more likely to be credible evidence. So on any case, on any of these things, my suggestion to you in the strongest of terms is to keep as much evidence as you possibly can. And then when you present it, and you present it clearly and fairly, you are much more likely to be believed. So I hope that some of that is useful in any of the situations you might find yourself in. Please do hit that like and subscribe button. I really appreciate that. YouTube spreads these videos around much more when you do that. And hit the bell icon if you really do want to get notifications of my new videos. And in the meantime, thank you for your time, and thank you for watching.